And we'll begin with Pledge of Allegiance, please. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. We'd entertain a motion for approving the minutes.
So moved.
Second.
Support. Any discussion? All those in favor, please say aye.
Aye.
Any opposed? Minutes are passed. We have the addition of a training session at the end of this meeting. The community is welcome to attend, but not necessary. And with that, we'll just say we'll now consider the 355 Pine Ridge Drive for a setback variance to install mechanical equipment in the required side yard. And Eric, one thing I'll ask you to do, please explain the difference between a required and a not required side yard and why it should make a difference.
Okay, surely. Okay, good afternoon, everyone. My name is Eric Peach with Giffords Webster, the city's planning consultant. Our first item under consideration is 355 Pine Ridge Drive. This is for mechanical equipment located in the side yard setback. So to begin, we show that this is the A2 zoning district, so the district standards of the A2 of the zoning ordinance are what applies here. As you can see, the uniqueness of this lot is it takes access from Pine Ridge Drive to the west, a cul-de-sac, and has a very narrow southern portion. This may look familiar. We saw this back in March of 2015. This development received a number of variances, primarily as it relates to the setbacks, because as you can see in this aerial, the houses that align facing the golf course to the south is the reason why the house was proposed in line with those houses as well. And then as you can see up to where there is potentially more buildable area, you can see that that's where the driveway comes in to service access to the property. And that will remain. So the area of focus today is primarily along this western property line adjacent to this existing house to the west. It's of note that both of these parcels, the one to the west and to the east, are under common ownership. And so it is the owner of this parcel that is developing the adjacent lot. So just to give a little bit of brief history, the configuration that we see the lot in currently, lot 16, is because it was platted that way in 1978 as part of the Echo Ridge subdivision. And so it's these property lines that have always existed in this manner. So again, the lot is unique in the sense that it does not meet the width standards. So up here, circled in blue, you can see that the standard for the A2 district is 175 feet in width. Here we have approximately 164 feet. So that is not something that was done by the applicant. It's just the nature of the property. So it is a challenge, or it was a challenge, to fit a proposed development within such a lot. So going back previously, this is the layout of the home that again was approved. They had the primary residence here on the southern portion, and then in the front yard is a detached garage. And the ordinance says that you cannot have a detached accessory building within a front yard, so that did receive variance approval as well as within the setback. As you can see here, there's this pink line, that's the required setback. So now would be a good time to kind of just differentiate between the required yard and the non-required yard. So all that really means is that when you have a required yard, that just means that the portion of the yard, so for example, everything to the east of this pink line is the setback, that's required to remain yard, is the way that I always think of it. So it has to remain as such. You can't build within a required yard because it's required to stay yard. So whenever you see within our letter that terminology, that just means that something is proposed in a required yard and it's not permitted to do so, and so therefore it would be in violation of the ordinance standard and would require a setback variance. So zooming in with the current site plan, what was approved back in March was, at the end of the presentation, I'll show the number of variances that were granted, but among those was the mechanical units that were proposed and approved in the side yard to the east. And the reason why those were proposed in that location first and foremost was because of the way that the lot is oriented narrowly with the existing home to the west in close proximity. That's about a 3-foot setback from the property line to the existing house. So that limited the area between the two buildings once the new one is constructed. But over on the east side, there was a small area that the applicant was able to fit the mechanical units that were not in close proximity to the house to the east. So the house to the east is set back obviously much further than the 3 feet that the house to the west is. So this is what was looked at that time. This is the east setback, and this is the required yard. So it's the side yard, and because it's within the setback, this whole area is required to remain yard without any proposed items in it, except that because the house is taking advantage of the setback lines, the only area that resulting area for the mechanical units was within the setback. So they were approximately 27 feet from the east property line here. And then the required setback is 34 feet as represented by the pink line. So refreshing memory, if you do recall this application, if not, this slide is intended to show some dimensional aspects. So the ordinance says that the mechanical units must be within 5 feet of the house, which the mechanical units are highlighted in green here. They are 27 feet from the property line. So here's our property line here in black. And then our 2 setback lines of 34 feet each on the subject site, and then 34 feet on the adjacent property. So when we did a dimensional separation distance, 34 and 34 is 68. So when you measure those equipment, the mechanical equipment to the closest points of the house, in no instance do you have a distance that's less than 68 feet. So in that sense, we believe that it met the spirit of the ordinance, and so that's why we moved forward with an application for a variance request, which again was granted in March. If you recall also, there was opposition from this property owner with legal representation, and so it was agreed upon that the applicant would consult with that neighbor, discuss options with that neighbor to be a good neighbor, and so that's what brings us back today, is that they would agree to relocate the mechanical units to the west side of the property, and we do have indication that there is an agreement between the two neighbors that that's the way that they would pursue this.
So does the same person who wants to build the house also own the lot?
The 2 lots, the subject site here and the one to the west, is under common ownership. So yes, they do have, both properties are under the same.
Permission to do the other side of the house actually is the owner.
Is the owner.
Yeah.
Yes, ma'am.
The neighbor rejected it on the other side.
That is correct. Yes,
Could I
ma'am.
amplify that question? Will it always be the same owner?
No. And that was discussed at the previous meeting, yes.
But the memorandum of agreement runs with the land and would be enforceable to the next subsequent owner were there to be one.
So we have not been provided with the memorandum of agreement. The
That's in the
memorandum
package.
of agreement does not implicate the township's action. It's not enforceable. It runs with the land in that this mechanical equipment, once located on the east side, will always remain on the east side. There's nothing that a subsequent property owner who's unhappy with the location, the distance, will be able to do to move or to either force the township to provide a variance or to move it to the other side.
That's correct.
So-
Once that variance is granted, then legally that will run with the land.
Correct.
It's permitted.
Yeah, the decision, the board does not have to make a decision, or is not forced to make a decision by the existence of this memorandum. But if it were to grant this variance, there would be no concern about a subsequent property owner being able to move it or forcing the township to allow a different variance.
I guess I would add a little bit too, from a legal perspective, the memorandum between the two parties has no bearing on the city's actions.
Correct, that's,
It's
But
worthless
it might
paper.
affect the next owners.
It will absolutely affect the next one.
right.
So the house will go on the market and the people will have to accept it.
They'll have to live with where that is.
They'll have the advantage of hopefully
Seeing
being
it.
able to see it, exactly. So they'll know that there's mechanical equipment,
There's a noise
To
every so
reframe
often
that-
as it's running, so.
If their title and abstract company is doing its job,
yes.
they will know that
And
they're
that-
also accountable.
That may not happen, it should happen, but it may not happen, but that's not the city's,
I don't need to be concerned with that.
yes.
I have no right to be concerned.
You can certainly be
Okay.
concerned about that, but doesn't necessarily weigh on this.
And so just to clarify, the mechanical units are going from where they were approved on the east side to the west side of the house. So if you took this image and tilted it to the right, that would be north. So again, the major factors here are this existing home, which is existing nonconformity. It encroaches this setback requirement here, 26 feet. It is in close proximity to the property line at 3 feet. So the distance between the proposed mechanical units to the property line is about 21 feet. So adding a 3-foot distance, that would be a 24-foot separation from the existing home to the mechanical units. So as we move forward, the screening of the units, there will be the 5-foot dwarf European hornbeam around the perimeter of the units, as well as a landscape wall, approximately 3 feet in height. So those two items will help to screen. This is an image of the dwarf hornbeam just by a Google search. And then what's highlighted in blue is a roof awning. So the units will sit underneath a portion of the home that cantilevers the roof over that part of the house and property. So looking at an elevation towards that section of the house, this would be the front, this would be the side, and then this would be the portion of the house that faces the golf course. So this would be looking at the existing home that's in close proximity to the property line. So here you have this low 3-foot landscape wall. The roof eave is about 4 feet, cantilevering past the side of the house. And as you can see, there's no window units lower on the facade of the house. The windows are higher up. And I believe that's the kitchen on the opposite side of the wall. And then, of course, you'd have the English hornbeam that would be surrounding the wall area here to help buffer the noise and visuals. So on the previous application for the units to be on the east side of the home, we did have some neighborhood support, but again, the neighbor to the east did not support. That's just to show kind of the trajectory of where this application has been. And then this was the variances that were approved in March of this year. So you have the primary house here. The house itself, the structure, complies with the minimum setbacks of 34 feet and 26 feet. It's just that when you apply the algebraic setback, there were some issues. The applicant did a really good job with getting the home to fit as minimally as possible. By that I mean minimal amounts of variant. But there were algebraic setback variances that were granted. Item number 1 was a post for the cantilever of the carport in this location. And then, of course, the detached garage had a setback variance request. So it's number 7 that we're taking. That's the only change to the application, is to relocate the mechanical units from the east side to the west side of the house. Are there any other questions?
To the best of our knowledge, no neighbor has expressed further concern.
Not to my knowledge.
But it really comes down to this, there's a nameless neighbor, right, because it's common ownership. So if someone lived there, presumably if you lived there, you'd be here saying, I don't want to hear, and it'd be bouncing back and forth. Now, there is a remedy for that, like, I don't know, whoever said it, whoever's going to buy that home in the future is going to see that and presumably going to adjust their price accordingly. That would be the remedy.
Great. Any other comments, questions? Is the property owner here? Or their representative?
I'm a representative here. I'm the architect working on the project. The property owners were not able to make it today.
You want to add anything at all?
No, I think Eric did a great job covering everything, so I'm happy to provide any additional comment if there are questions for me specifically, but
We're ready for a motion or further discussion. Who wants to make a motion?
This is interesting.
Just for the board's edification, just to clarify, the board is under no obligation. The board was not a party to this memorandum. The city was not a party to this memorandum of understanding, so there's no obligation one way or another. You can make your decision based on the standards of practical difficulty as if you would for any other variance application.
David, I'll go ahead and, I move to approve a variance from section 24-229B11 in order to allow mechanical equipment in the western side yard setback. The applicant has demonstrated practical difficulty for the following reasons. One, strict compliance with the requirements would unreasonably prevent or severely limit the owner from improving the property, as the lot is long and narrow and thus proposes significant challenges when the city's algebraic setback analysis is applied to the east and west sides of the parcel. Two, the requested variances would do substantial justice to the property owner as well as other property owners when this item was considered at the March 18, 2025 meeting of the ZBA. The neighbor to the east objected to the placement of the mechanical equipment on the eastern side of the lot. Since that time, the neighbors have entered a memorandum of understanding and have agreed to request the mechanical equipment be located within the 26-foot western setback. Approving this change will not only provide the lot owner with needed mechanical equipment, but will also do substantial justice to the neighboring property owner. Three, the plight of the property owner is due to the uniqueness of the property. The lot is very narrow, and the uniqueness of the lot limits reasonable locations where mechanical equipment can be located. Four, the proponent's problem is not self-created, as the lot size and shape make it inherently difficult to site mechanical equipment outside of the setbacks on the east and west sides of the property. And five, the granting of the variances will not adversely affect the purposes or objectives of the master plan. The purpose of the master plan in residential areas is to allow homeowners the opportunity to improve the property while minimizing impact on the neighbors.
Thank you. Is there support?
Support.
There's support. Any further discussion? If not, then those in favor, please say aye.
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 Any opposed? Motion carries. Thank you. I will move on to the request from property owner at 1040 Orchard Ridge Road for a variance to allow an accessory building to be located in the non-required front yard.
Okay, our next item for consideration is 1040 Orchard Ridge Road. This is located in the A1 zoning district, so it's our larger lots. And the A1 zoning standards apply. So looking at the existing survey of the home, this application received Zoning Board of Appeals and Planning Commission approval in November of last year, or 2003, excuse me, to modify and reconstruct this area here. So this is the home This is Orchard Ridge Road, and the driveway access to access the home is this kind of curly Q driveway here. So the home, as it exists, faces north and has its back towards Orchard Ridge Road. So when you look at a yard determination graphic, the front yard between the home and Orchard Ridge is highlighted in green, even though the home faces north. The two side yards are shown in yellow, and then the remaining yard is orange, shown to the east. So with that being said, the orientation of the home, the existing amenities that the house enjoys are to the north and west, and that's exactly where the proposed improvements were approved, and where there's this modification before you again today. So back in 2023, these were the items that went to the Planning Commission for approval. Item 1 is the reflecting pool. Items 2 and 3 are a pavilion and a cabana, which are shown in this image on the upper left. And item 4 was a plant arbor, pergola type of structure that was connected to the house. So when these approvals came in for building permits, it was determined that items 2 and 3, the cabana and pavilion, this image here, were removed from the plans. So even though they received Planning Commission and variance approval, they did not get permitted because the applicant had opted to leave them off. So if we look at the cabana and the pavilion here, this was never built, never permitted, and what's before you today is the alternative, and that's what's shown in this color image here. It's more of a simplified pavilion type of building, bless you. And so the location is primarily the same as what was previously proposed and approved. Here's the reflecting pool here, here's the home, and the arbor and the patio shown here. The distance will be approximately 139 feet from the front property line. If you've driven past the site, it's a heavily wooded front lot, so there's no views from the street into the site. And then to the north property line is a distance of approximately 103, 104 feet. And then just to, for the record, the Zoning Board of Appeals both approved the reflecting pool in the front yard, in a front yard that's less than 3 times the depth of its setback. So in other words, the front yard was too narrow for the pool, the reflecting pool, to receive administrative approval. And then for a front yard accessory building is what the zoning board approved in 2023. And then lastly, these are some renderings showing the location of the pavilion in relation to the existing home, and then the additional improvements that are currently under construction, I believe. This is the reflecting pool, and then where the proposed pavilion will be located. And if you stepped out of the house and looked towards the pavilion, this is what you would see, the reflecting pool, and then the proposed pavilion there. As you can see, it's heavily wooded, facing, somewhat facing Orchard Ridge in that general direction. And then turning around underneath the proposed building, you would see the home, and then this is that pergola structure that was approved in 2023.
Is that bluestone, is that already all laid out and they're just putting I'm just curious, was it add-on? Yeah.
Would you like me to address now?
Yeah, that'd be great.
Yeah, the bluestone patios and steps that you're seeing there are part of the development. They're not there.
They're not there, got it.
And then just another perspective from the northish side of the property, looking towards the house and the pavilion. And then if there's any questions about the standards that we looked at, this is the table that we do that. You'll find this in your letter. But it's because this permitted pavilion, cabana type of accessory building was never permitted. The owners opted to pursue it again, just in a more simplified manner. Shown here what was approved and what's currently proposed, roughly in the same location as what was approved before.
What's the acreage of the lot?
The acreage is, well, it's 166,735 square feet. So whatever the math is to find the acreage, I'm not entirely sure.
2.5 acres.
2.5.
Pardon?
2.5 acres approximately.
Is there electricity going to this pavilion?
Yes,
Yes? What are you gonna use it for?
the roll down fans for the insect springs.
Okay. So it's gonna be sitting room, whatever you wanna use it, okay.
Well, it's very protected by trees
Yeah.
and rock.
Are the dimensions of the structure relatively the same from what was proposed earlier? Or what was approved earlier?
I believe it's smaller because we had, sorry. Yeah, because there was the two combined pavilion and the cabana. So it's brought in towards the house to a certain
The
extent.
glass portion is roughly the same. Just the-
Does anyone wish to make further comments or pose questions? Now we're ready for a motion. Would you like to make a
I
motion?
can, Mr. Chairman, I move to approve variance 24-229A2 to allow a pavilion accessory building to be located in the front yard in lieu of the rear or side yard. The applicant has demonstrated practical difficulty for the following reasons. One, strict compliance with the requirements would unreasonably prevent or severely limit the owner from improving the existing site. The existing home is 100 years old and has an existing pool and cabana which currently exist within the front yard. The property owner proposes to replace the existing structures with a smaller, shallower, reflecting pool and modern pavilion. Two, the variance would do substantial justice to the property owner as well as other property owners, as it would permit the property owner to update the existing features. Additionally, while the proposed improvements would be in the same general vicinity as the current accessory features, the overall footprint of the affected area would be reduced, thereby reducing the pre-existing nonconformity. There is an existing landscaping which will screen the improvements from both the neighboring properties and Orchard Ridge Road. Three, the plight of the property owner is due to the uniqueness of the property. The home on the property is nearly 100 years old, and the layout and design of the property necessitates a variance to allow the property owner to modernize and improve the existing accessory features. Four, the proponent's problem is not self-created. The orientation of the home and existing accessory features predates the city's zoning ordinance. Five, the granting of this variance will not adversely affect the purposes or objectives of the master plan. The purpose of the master plan in residential areas is to allow homeowners the opportunity to improve the property while minimizing impact on the neighbors.
Thank you for making the motion. Is there support?
I'll support.
Support. Any further discussion? If not, those in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you. So the formal meeting is over. The training session will now begin.
There will be a slight delay before the training session begins. Mark Roberts will be running the presentation, and he is coming from Waterford. So if anyone has to use the restroom or take a little break,
If we have been through this before, do we need to go through it again?
there's always, we recommend that, you stay for training. More training is never a bad thing, but of course.
Well, actually, it's the city commission's goal this year, to have all boards and commissions trained. And so, on an annual basis, and we did talk with the chairman, Mark Roberts, and I about the training and some of the finer points. I don't want to take away Mark's thunder, but there's just, really the purpose of it is just so that, we just kind of go over the procedural duties, ethical responsibilities, and functional role of all members. So if you could please, wait a few minutes for Mark. He's supposed to be here, but I guess he was caught in traffic. I don't know. If he doesn't show up in the next 5 minutes, I'll do the training. So,
There you go.
There you go.
How long are we thinking,
we'll figure it out here.
how long are we thinking for the training to last?
There he is.
Not long. He's
There he
here
is.
right now. Thank you, Mark. I was almost had to step in for you here. Over here. And,
Right on cue.
It's gonna be brief.
Come on over.
We just finished.
Anyways, yeah, so, all right, take it away, Mark. So, just want to introduce Mark Roberts. I don't know if everybody's met Mark yet, but our previous main city attorney, Dirk Beckerleg, retired, and Mark's our new city attorney, so he was asked by us to provide this training, and again, this training really is a commission goal, so the city commission, so they directed us to make sure all boards and commissions are trained. So thank you.
And I won't take too much of your time, I promise. I look at this, tentatively called training, but I kind of think maybe this is more of a review. I know you're all experienced, and I've heard good things about the ZBA through my colleague. So I basically just wanted to go over kind of the basics, the origin of the ZBA, and its purpose, the guidelines for the meeting procedures, the different types of matters the board will be called upon to address, and a couple other concerns that I was asked to address earlier. The origins and the purpose of the Zoning Board of Appeals, really the genesis is the Zoning Enabling Act, which is the legislation, the state legislation which bestows upon local municipalities the authority to regulate land uses in their city. The Zoning Enabling Act recognizes that, as a zoning ordinance, it's going to be applicable citywide to a large variety of properties, each one unique. And because of that, the Zoning Enabling Act recognizes that there needs to be some type of safety valve built into this. That's you're the safety valve for the city's zoning ordinance. The organization, 7 members appointed by the mayor, confirmed by the city commission, up to 2 alternates. 1 member is also a member of the planning commission, and 1 member may sit on the city commission. 3-year terms for the members, staggered, and at the beginning of the year, there's annual elections for the officers of the ZBA, the chair, the vice chair, and the secretary. Also at the first meeting of the year, typically you'll adopt the schedule for the rest of the year, which is important for compliance to the Open Meetings Act. So that's kind of the background, organization, and the authorization for the zoning board. The purpose, again, I go back, this is the safety valve for the zoning ordinance. So you're going to be, as the safety valve, you're going to be evaluating individual properties and the application of the zoning ordinances to those individual properties when it's brought to your attention by an application. There's a couple other functions of the ZBA, however. You're also responsible for the ultimate interpretation of both the map and the text of the zoning ordinance for the city. Probably don't function in that function often, but if there is an issue that arises with a zoning ordinance and how it's going to be interpreted and applied, the city has the right, or the applicant has the right, to come before the ZBA and ask you to interpret this ordinance. And based upon that interpretation, a record is kept of that, and that will apply moving forward. So that's an important function for the zoning board. Probably won't be called upon to address that very often, but it is an important function. Similarly, the board is also the appeals board for decisions of the city administration. If there's a decision made by, say, a building official or somebody in the administration, where there's disagreement on that, that person can come before the zoning board and ask the zoning board to listen to what happened, basically, and then make a ruling on whether the decision of that person was correct or not. Probably what you're more familiar with is your function as hearing and deciding variance applications. And I would imagine at least 90% of the decisions you make involve non-use variances. They're by far the most common. And again, this is where you have an individual property where there's something unique about this property that's different from the other properties that are in the district for which the regulation is designed. And in order to fairly impose that regulation on this particular property for one of the specified reasons, it requires a little bit deviation from the zoning ordinance requirements. That's termed a non-use variance. There's also use variances, which you probably don't address as often. It's a little bit more complicated of a process and a little bit more stringent application of the zoning ordinance and more criteria that need to be met. Higher standard requires a vote of 5 members, not just 4, in order to pass. And there's a lengthy process spelled out in your ordinance for that. Couple other probably less recognized, there's a couple areas of your zoning ordinance that specify a use is permitted upon approval by the ZBA. That would be something you'd be asked to address. Also, interestingly, you've got a stormwater management regulation ordinance, which requires the ZBA to treat that almost like a zoning ordinance in case there's a request to deviate from the requirements of the stormwater management. And you would be called upon to address that. So those are kind of the background, the types of things that will be presented to the zoning board. Having just finished a meeting, you're probably very familiar with the procedures to be followed at the zoning meetings. We call the meeting to order, pledge of allegiance, approve minutes, and then you call the first case. When a case is announced, typically the chair would announce the case and then recognize the planning consultant to present the city's version of what the application's about, a discussion of the ordinance provisions at issue, and a brief discussion of what the applicant is proposing to address those and some of the principles that you'd want to apply in making this decision. Typically after that's done, the applicant would present, and they would be before you to present their arguments on why their variance should be granted. And again, this is their opportunity to present their case to you. Each variance request is a public hearing, requires a public hearing for the members of the public to voice their either support or opposition or any comment they may have. So the next phase after the applicant is given the opportunity to speak, there would be open public hearing. You'd hear from anybody that wishes to speak. And this is something we talked about earlier. If you don't already have it, I'm going to make a recommendation that you adopt some rules for that public hearing, specifically rules related to how long somebody can speak. It's pretty common to limit speaking to 3 minutes per person and some other provisions. And I believe you do not have such rules, and I would recommend that we draft some and they be adopted.
Do other boards of the city have rules like that?
I'm sorry?
Is it just this board that doesn't have rules on speaking, or the other ones don't have it either?
I don't know if the other boards.
They do?
Okay.
Okay.
I know it's very common for ZBA to have them.
Can we borrow yours next time?
And you do have PC you do have ZBA bylaws.
Yep.
It may or may not be in there, but we'll double check.
I don't believe it is, but Anyway, I would suggest that. Again, we'll look into that, and if you don't have them, we'll prepare them and have them adopted by you. So basically, after the public hearing, after the public is done presenting, you would close the public hearing, and then the matter comes back for board discussion. And the board discussion at that point may be conversations amongst yourselves based upon what you heard, what you read in the packet, what you heard by the planning consultant, the comments made by the applicant, maybe the members of the public. But it's also an opportunity, if you've got specific questions of the planning consultant, maybe at that point they would be posed to the planning consultant or to the applicant. And then following that discussion, there would be, when the discussion's more or less over, there would be a call for a motion, and a motion would be made and seconded. And then there may be a call for further discussion on the motion itself, whether the motion covers all the factual basis that you feel are important, or if maybe there's a minor tweak to the motion, you could make a recommendation for a friendly amendment at that point. And then after the motion discussion and any amendment, there would be a vote called. And then at that point, obviously, you'd call the next case and do the same thing over again. When you get through everything, and there's the adjournment, there's nothing further that needs to be done. Now, the types of decisions are going to be, they're going to call for different criteria. By far the most common, as I indicated earlier, are the dimensional or non-use variances. These are the ones where, you know, like the deviation from like a setback or from a building height requirement, something of that nature. And the board, with just a majority vote, so a majority vote of the members, not the persons present. So every time it requires a vote of 4 for a non-use variance. You can grant a non-use variance upon a finding that compliance with the strict letter of the restrictions governing area, setbacks, frontage, height, bulk, density, and other dimensional provisions would create a practical difficulty. Practical difficulty is the standard for a non-use variance. And in order to find a practical difficulty, you need to find all of the 5 criteria are present. The strict compliance with the restrictions governing the area, setback, etc. Other similar items would unreasonably prevent the owner from using the property for a permitted purpose or would render conformity with said restriction unnecessarily burdensome. The next criteria would be the variance would do substantial justice to the proponent as well as to the other property owners in the zoning district, and whether a lesser relaxation of restrictions would give substantial relief to the proponent and be more consistent with justice to the other. That's an important one too, because bear in mind, the applicant's going to be coming before you requesting, say, 15-foot setback variance. You don't have to either give him or reject a 15-foot. If you think that, he could get by with a 10-foot, you can do that. You can give him a lesser variance if it's consistent and, frankly, more consistent with justice to the others in the vicinity. The next criteria would be the plight of the property owners due to unique circumstances of the property. That's an important one because, again, as I mentioned earlier, the whole purpose of the Zoning Board of Appeals is kind of the safety valve. So you're dealing with the unusual situations, and a big factor is the unique shape of a property, or if there's unique features in it. I believe your community has a lot of, say, contour deviations, so there may be a steep area of the property that has a severe elevation change. Might be something that would be difficult to build a house on. That might be something you'd want to consider for a variance. So it's not just the shape of the property, but it's also what the contour is, whether there's wetland or forested area or things of that nature. So It's the unique circumstances on the property, and the applicant is responsible for bringing those to your attention. The proponent's problem is not self-created. That one can be a little bit tricky sometimes, because if somebody buys a house that's already built and they want to put in, like a pool or something, but the house was placed too close to a lot line to let a pool be developed, that's not necessarily something that's self-created by the applicant. They would have a right to come before you. You don't need to grant it, but that's not something that would be self-created. In my mind, self-created is more, bought a vacant piece of property and I want my house way back here, and in order to do that I need a setback variance. Where they haven't, when everything's just a plan at this point, that's not really that would be a self-created hardship, not where there's an existing home that somebody's trying to fit something on. And then the last would be the granting of the variance would not adversely affect the purposes and objectives of the master plan of the city. And that's, kind of the overarching principle. Again, the zoning ordinance is the regulatory outline of the city that it uses to enforce its master plan goals. So if a variance is going to have a severe impact upon the master planned concept that the city is looking to adopt with its zoning regulations, that might be something that you want to steer clear of, or somehow fashion a variance relief that would be less impactful on that. But those are the criteria for the non-use variance. And again, you need to find all of those present. It is the burden of the applicant to demonstrate all of those factors. And if he successfully does so, you should grant the variance. Or if there's a lesser variance that's required, you could give that. But if you're applying these criteria, you need to apply them, and this is kind of a big issue with a lot of ZBAs, you need to apply them consistently. So you're not going to look at individual properties and say, yeah, that would probably work here, that wouldn't work there. No. You're going to look at your criteria and you're going to follow the criteria. And if it meets the criteria, then you can give the variance. If it doesn't, you need to deny it. And in crafting a motion, I understand that you're provided sample motions. I would encourage you to review those motions. They are suggested motions, and to the extent that you hear the input from the applicant and from the public and from the planning consultant, and there's something else that's not in the motion, feel free to add it. If there's something that's in the motion as a basis for whatever action is set forth in the motion that you don't feel was presented, that wouldn't be applicable, then feel free to strike it out. If you reach a different conclusion, by all means, adopt a different motion. These are just suggestions. The big thing is to make your motion clear, and in support of your motion, provide the factual basis for your determination on each one of those 5 criteria that you've evaluated. And I know, I don't know if you're familiar with this sheet. We can distribute these if you'd like. These are basically form motions, and there's blanks here for each of the criteria.
They actually do a really good job with this
Okay.
portion of it. Can you move on to the next?
Sure.
Part of the training?
Yep. Okay. And then the next type of variance you'd be required to address is a use variance. And again, that's a little bit different. A use variance is not dealing with area or measurements of the land. It's dealing with the actual use. And it's a little bit more involved and a little bit more technical. And there's a very extensive process set forth in your zoning ordinance for that. But the standard involved is unnecessary hardship, which is a higher standard than a practical difficulty. And what you're doing is you're authorizing a use that is not otherwise permitted in a zoning district, but it is something that the applicant desires to do, and the argument is all the permitted uses in the zoning district are not possible.
Can you give an example?
Um,
Because I don't believe we've had,
Can you try a marijuana shop?
That might fit, yeah. You probably have never seen one because they're fairly uncommon, to tell you the truth.
We have not seen one,
Okay.
to my knowledge.
What
If
is
you
it?
have,
So this is a use variance says
a
this
use,
is zoned residential and I want commercial.
right,
Oh, okay.
yeah, it's a request to vary the terms of a use restriction in a district on a piece of
And
property.
an area variance is, the numbers don't work when we apply the formula, or it's too close to the front of the
Right.
lot or the back of the lot. That's almost all
Right.
that we get.
Right.
Non-use variance is also called a dimensional variance, and I think that kind of
Area
is more
variance,
explanatory
dimensional
of it. The
Non-use.
use variance, like I said, is much rarer. Frankly, I think, we spoke about this earlier, I don't think you've dealt with one in the last couple of years, so, like I said, it is very rare. I did want to touch on it, though, because it is a different procedure and it's a different standard. A lot of times with the dimensional variance, you'll hear people say, but I have an unnecessary hardship. That's not the standard for dimensional
But play
variance.
with it, just in response to your question. Give us an example of a use variance.
Trying really hard to think of one right now.
What about an
Amy, go ahead.
ADU,
What,
for elderly parents in the back? Would that be a use variance?
for which?
An ADU in the back, additional,
Could be. The one I was going to suggest would be like a restaurant that serves alcohol. If you had, and this is just an example, if you had a district that allowed restaurants but did not allow them to sell alcohol, in such a situation, an applicant would come in and say, I want to have a restaurant that has alcohol as a use. And here's why I can't make any other use work. And the standards are, the applicant's property cannot be used for the purposes permitted in the zoning district. And the argument, I suppose, would be a restaurant on this piece of property is not going to work unless there's alcohol sales because of the competition in the area. We wouldn't be able to make it work. The applicant's plight is due to a unique circumstance particular to his property and not to general neighborhood conditions. The applicant's suggested use would not alter the essential character of the area, and the applicant's problem is not self-created. Those are the four criteria for a unnecessary hardship. And in order to grant that, it would require a affirmative vote of 5 members of the zoning board, not just 4. So it's a higher criteria. And it's again, a more detailed application process. That process is set forth in your zoning ordinance, section 279B. It is a fairly lengthy process, so I'm not going to go through it unless you want to. But I'm presenting it because it's one of the authorities that you're given is to grant use variances when appropriate. Another type of decision, as I touched on earlier, is the appeal. This is the appeal from the administrative official, and it would be presented to you, and you would listen to the appeal, the background for it, and you would make the determination of whether the decision was arbitrary or capricious. whether the decision was based upon erroneous findings or material fact, whether the decision constituted an abuse of discretion.
So would this be, the building official says no, and I disagree with the criteria he applied? Or his I disagree with his application of the
Right.
criteria.
It may be, the building official is saying, I'm measuring this setback from this point of this building, and the applicant is saying, no, it should be measured from this point of the building. That would be a decision of the administration that could be appealable to the ZBA. So either, you'd apply these criteria and you'd be evaluating to see whether that decision of the building official should be reversed or not. So I think the appeal is kind of self-explanatory. It's a specific question being addressed, and you're going to evaluate based upon those 4 different criteria whether to affirm that decision or to reverse it.
I have a question.
Mm-hmm.
Not long ago, these people who bought a lot very close to Woodward Avenue had been working for 4 years to get approval to build this house. Well, at the last minute, they decided that they needed a swimming pool because they had a child who was physically disabled and needed a pool. Well, this pool ended up 25 feet from Woodward Avenue. Does anybody remember that?
Yeah.
25 feet, and every time I go by that house that's being built, I think of this pool.
Is
and
it
this
envy for today, or?
And this disabled child who's going to be swimming in this pool. And I did not approve it. Everybody else approved it, and finally it's, are you going to approve it? I did end up approving it, but what it makes you think is if you approve something like that, that surely could not be an appropriate thing to do when you're that close to Woodward Avenue and all the traffic, trucks and all that. So what if a truck rolls over and hurts this child who's in the pool? The fact that we approved this, what does that say as far as the city and the people who approved it?
There would not be any liability established there, in my opinion, based upon those facts.
Only a personal liability.
I won't argue that point.
Right.
What I would suggest, based upon that example, however, is an important point the board needs to bear in mind as
Right,
well.
which is why I brought it up, because it is kind of a general thing when you're approving these zoning issues.
Well, what I was going to say is I understand the situation. The application was brought before you because I've got a disabled child. I need this pool.
Yeah,
That's not something you can consider. Has absolutely nothing to do with the property.
mm-hmm.
And the thing to remember is when you grant a variance like this, it runs with the land. So you're not addressing this placement of the pool for this particular disabled child. You're addressing the position of this pool into the future, no matter who's there. So that's an important thing to remember, is that this is not something that's personal. And I go back to the original criteria for the dimensional or non-use variance, which this would be. That's something you want to follow. Follow strictly those criteria. There's 5 of them. Not one of them is anything to do with the needs of the particular resident at that time. Another big one is I need a longer driveway or a larger driveway because I've got kids and they need a place to park. Doesn't matter. that type of consideration, I'm not saying in this community, but that concept with that type of regulation and the request of the variance, it's not really something that has to do with the property, so that's not something that you should be addressing. Does that make sense?
Yeah.
Is there any other questions on the application and those types? The other thing I wanted to go over is just kind of the general principles for your service on the ZBA. And in particular, like the conduct of the meeting. Your bylaws indicate that you're going to be following Robert's Rules of Order, and I wanted to touch briefly on that. The Robert's Rules of Order are kind of a complicated, arcane system that works well probably for corporation meetings and national legislature, but they don't really work well for a small body like this. But they do have some principles in them that I think are advisable. One, regarding conversations during the conduct of a hearing. Try to avoid sidebar conversations. You know, like lean over to your neighbor and, you know, start having a different conversation for a couple reasons. One, it makes it difficult to keep the minutes, if nothing else. But you can also give, you can make the audience or the applicant question what's going on. You know, what are these two talking about? I can't hear what they're saying. Creates suspicion. I will say Robert's Rules of Order doesn't prohibit it. What's prohibited is having that kind of discussion where you're going to be interfering with the meeting. You can't do that and interfere with the meeting. You can have a sidebar conversation. So it's permitted in Robert's Rules of Order. I'm just saying avoid it as much as possible for the reasons I gave.
We kind of adhere to the Open Meetings Act so that we're not likely to have any side conversations.
It also touches on Open Meetings Act provisions, but I'm addressing now the Robert's Rules of Order standards that are applicable to the board through its bylaws. Another big one, and I know with a smaller board, the tendency is to do this because it's frankly, and Robert's rules recognize this. It's a smaller board. It's more informal, but it's important to wait to be recognized to speak, and it's important for the chair to keep an eye out for somebody that's, you know, looking to be recognized. But it's important, again, for the record keeper that you know, one person be speaking at a time, and in that regard, the chair is under the larger Robert's Rules of Order is supposed to be neutral and not participate in the conversation. Again, Robert's Rules recognizes that in a smaller board that's not workable. So for a board like the ZBA, the chair can participate, but I would encourage the chair to be more focused on recognizing people that want to speak and hold back a little bit. Participate in the conversation as you feel you need to, but your primary role as the chair is to keep the discussion on topic. And, you know, if somebody starts to wander off, then bring them back into the topic, which would be, you know, the criteria that you're supposed to be focusing on. The other thing with the chair can do is kind of govern the discussion. So if there's discussion on one point that's not finished yet and somebody raises another issue, the chair may say, you know what, that's a good issue. I'll make a note of it. Let's finish this topic and then we'll move to that one. So that one, you can organize the conversation a little bit more and try to keep everybody focused on an issue until it's decided. The other thing the chair can do is, as I indicated, when the public is called, they're free to speak. They come up, they're typically given 3 minutes to speak, and then they sit down. At the close of the public hearing, public participation is done. And so if the meeting's progressing and somebody speaks up from the audience, member of the public from the audience, it's appropriate for the chair to stop, say, I'm sorry, public comment's over. We're at the board now and you're out of line. Okay.
As long as it's orderly, I would probably flex on that criterion.
What I'm saying are what you should be striving to. Obviously, there's exceptions to everything. And again, I recognize, especially in a small group like this, that may be something to consider. But what I'm saying is typically you should avoid engaging in conversation with members of the audience, even just in discussion after the close of the public hearing. You can ask questions of the planning consultant, you can ask questions of the applicant. I would not go back to the members of the public. Just because you don't want to get engaged in a conversation, it's not that informal of a process. Now, it would be appropriate, for instance, if somebody raised something in public comment, you may make a note of that. You may want to ask the planning consultant, hey, so-and-so raised this point, what are your thoughts on that? That would be appropriate. But to start engaging in the conversation with the public after the close of public hearing, I think is something to be avoided. Again, depends on the number of people in the audience or what the issue is. You may want to indulge, but in general, it should be avoided. And again, the motion should be made and seconded. And frankly, when the motion is called for a vote, typically the chair would be responsible for reciting the motion. I understand there's proposed motions that are distributed, and so it should not be that difficult to recite the motion. You could probably, if there's no change to it, you could probably just refer to the written motion. The motion should be made verbally by the person making the motion, but when it's time for the vote, the chair could just refer to the motion that's been made and seconded and call for the vote at that point. If there's been a lot of changes or modifications to the motion, the chair should recite the motion before the vote is called. And then don't forget, as the chair, when you're calling the motion, if it's a voice vote, say, all those in favor say aye. If everybody votes, still make sure you say any opposed. A lot of people overlook that because it's not really, but it's important to do. Another consideration is the Open Meetings Act. And this one can be a little bit tricky because it's possible to violate the Open Meetings Act without knowing it. So the best practice is to have no communication with other ZBA members on ZBA business outside of a meeting. So, calling up, hey, you want to have a barbecue this weekend? No, that's fine. But what we're talking about is, hey, I just got the packet. I saw this application. What are your thoughts on, the setback request? That type of conversation should be avoided, even if it's just one-on-one. Technically, a one-on-one communication like that is not a violation of the Open Meetings Act. And I'm not saying you can't do it. There's probably going to be instances where you do it. What I'm suggesting is avoid it. Because all it takes is for one person to forward that on to somebody else, and then that person forwarded it on to another person, As soon as you got 4 people involved, it's deliberation, and you violated the Open Meetings Act. So like I said, it's easy to do, unless you're careful, it's easy to inadvertently do it, which is why I'm suggesting the safer practice is just avoid it altogether. And another purpose for that is that the board functions as a group, and it would be better to present whatever it is you're presenting so everybody can hear what you have to say, because again, the group is here to bounce ideas off one another and develop the best decision possible. And that can only effectively be done at the meeting in compliance with the Open Meetings Act. Covered already the email use, that's problematic. I don't know what your usual preparation for the meeting is, but if you go out to visit the site, which I think is an important thing to do, if you do go out to visit the site and somebody approaches you and wants to have a discussion with you, I would suggest the best thing you could do is, you know what, I'm here on official business. I don't think it would be appropriate to engage in a conversation with you without the full board present. I would encourage you to come to the meeting and express your points at the meeting. And if you're unable to attend the meeting, you can always submit written comments that will be presented to the board as a whole. Avoid a discussion with the applicant, avoid a discussion with any of the neighbors. I think the best thing to do is just to avoid that altogether. Gather information at the hearing from other sources. And as further information on the email traffic, remember everything is subject to FOIA, and as soon as you create and send an email, it's part of the official record. If it's ZBA related, it's part of the official record of the ZBA, so bear that in mind as well. Again, I would just avoid use of emails amongst you if you at all possible. Another issue I was asked to address is the matter of a conflict of interest. And this is all taken from your bylaws, by the way, so it's in there. A conflict of interest exists if any member has a personal or financial interest in the matter, or has an interest such that the member cannot be unbiased in the decision-making process. A member shall declare a conflict of interest when a relative or other family member is involved in the request before the ZBA, obviously. The Zoning Board of Appeals member has a business or financial interest in the property involved in the request, or has a business or financial interest in the applicant's company, agency, or association that's making their request. So I think you're kind of seeing the trend. If you got an interest in this, you should really bring it up and possibly recuse yourself due to a conflict of interest. Zoning Board of Appeals member owns or has a financial interest in a neighboring property. For purposes of this section, the neighboring property includes any property within the 300-foot area that requires notice under the ZBA rules for a public hearing. And then kind of the overarching principle, there is a reasonable appearance of a conflict of interest as determined by the Zoning Board of Appeals member declaring such a conflict. So if you identify yourself as being conflicted, you're supposed to raise that, disclose the conflict of interest before casting a vote on a matter. And if the majority vote of the remaining members of the board say, yes, you're conflicted, then you're excused from voting. If there's a conflict of interest that's recognized before the meeting date, I touched on the fact that the membership includes 2 alternate members. That's something that if you see, hey, you know, this is my daughter's house requesting a variance, I can't participate in this one, let the administration know and they can call in an alternate. and an alternate will come and sit on that one. And the alternate will stay on that case until it concludes. So if, you know, that it's before the ZBA one evening and the alternate's in attendance and it's tabled for some reason, at the next meeting, the alternate would then appear for that matter as well.
Now, if we know in advance, let's say that I can't make the next meeting, we don't necessarily invoke an alternate. Correct me if I'm wrong.
I don't believe that's the case. I believe the alternate's reserved just for conflicts, but if somebody has a vacation planned, it may be a situation where an alternate could be called. They are there to
Fill
a vacancy. And it's important because an applicant, and this is something to consider as well, even for a dimensional variance, the applicant needs 4 affirmative votes. No matter how many people are present, the quorum of the ZBA is 4. So if you have a bare quorum of 4 people, the applicant coming before you has to make sure everyone present votes affirmative. If you've got more people, a full board, he can afford to lose 3 and still have a positive decision. So that's something actually you may want to raise to the applicant, is saying, hey, we don't have a full board. Do you want to proceed based upon this type of consideration?
Alana, did you want to comment on that?
No, I was, in my head, I was like, oh, we've done that before. You guys have done that exact thing before. So I was like, yeah, they've checked that box. So I was
All
just
right,
giving
thank
a
you.
mental check note.
And again, I know none of this is new. I've just asked to provide this as a refresher. And you actually had asked about non-conforming uses. Just, is everybody familiar with the concept of a non-conforming either use or property? Or basically what it is, it's a property that when it was developed complied with the zoning ordinance, and then there was a change in the zoning ordinance that would prohibit that use or structure from being built today. Because of the property interests involved, the Zoning Enabling Act provides for a non-conforming use provision, and your ordinance has that provision as well. It allows the non-conformity to continue with some limitations. As soon as it's destroyed, it cannot be rebuilt unless it's in conformity with the then existing ordinance. If there's a change in use that changes to a conforming use, it cannot go back to the non-conforming use that was previously there. So those are kind of the things you'd be wanting to consider. Probably most appropriate for the ZBA, however, is a non-conforming use can't be expanded. And so if somebody comes in and they've got a non-conforming use because their property is has a 5-foot setback variance from the rear property line, and they say, well, we want to go within, we want a 5-foot variance from the side property line. Typically, the answer to that would be no, because you're expanding a non-conforming use. There may be some argument about that, but by and large, it would be trying to increase the nonconformity, and that's contrary to the purpose of the zoning ordinance, because again, the zoning ordinance is the regulatory tool to reach the master plan, and if you allow a nonconforming use to continue or even expand after it has reached one of those conditions, then it's not working toward the master plan, then it's working against it. So that would be one of the reasons for declining that type of a request. Does that make sense?
Thank you.
That's all I have.
Any questions at all? Really appreciate you hanging on for to listen to Mark. Thank you very much.
I do apologize for being late.
No problem.
Trying to get here from Novi was ridiculous.
You
Thank you.
Thank you.
Good, thank you.